let's talk about British Columbia's immediate roadside prohibition scheme. This is the 90-day roadside prohibition for failing a roadside breathalyzer test or for refusing to comply with the test. There are a number of circumstances in which you could receive one of these. The first is that you blow a warning on a roadside breathalyzer. The second is that you blow a fail reading on a roadside breathalyzer. The third is you say, no, I'm not going to take a roadside breathalyzer. You refuse to comply. And the fourth is you fail to comply with the roadside breathalyzer. Whether you don't say no, but you still nevertheless don't do the test. You don't put your lips on it. You don't blow. You might be, asking for a lawyer or something like that, which you're not entitled to. And that's failing to comply. Failing to comply also includes situations where you are unable to produce a sample. And even in circumstances where people have very serious or significant medical issues, the failure to comply can still be issued because officers are not diagnostic professionals at the roadside. So how do these usually start? Most of the time, there's some sort of a traffic stop or an investigation that occurs. An officer arrives at the scene of an accident, pulls a person over, does a sobriety check, a person drives through a roadblock. They very rarely happen at the doorsteps of people's homes. So if a person is pulled over at their residence or they are inside the house and the officer's responding to a complaint, that's usually not a situation that's going to lead to the immediate roadside prohibition. So somebody's pulled over and an officer either decides to do a mandatory roadside breathalyzer test, which means no grounds that they have to believe that you've been drinking. That you could have never touched a drop of alcohol in your life, and the police officer still has the right to ask you to blow into a roadside breathalyzer. In such circumstances, you would be required to provide the sample, and the officer's obligation to make that demand is that they must be in the lawful execution of their duty when they're doing it. The demand must be made immediately. They must be in possession of an approved screening device at the time that they make the demand. The test must be administered immediately after the demand, and you must be operating the vehicle. But if you're not operating the vehicle, like in the scene of an accident where an officer shows up after the fact, the officer can still form a reasonable suspicion that you have alcohol in your body. And that's based typically in the vast majority of cases where an officer decides that they subjectively believe that there is alcohol in your body, or at least suspect it. That they don't have to believe it, they just have to suspect it. And that suspicion is objectively reasonable. What you're going to see meeting that criteria in the vast majority of cases is either an odor of liquor on somebody's breath or admission to relatively recent consumption of alcohol. Those are the majority of cases. There are other circumstances where an officer could form a suspicion without those two factors, but those are very rare cases. There has to be something to put alcohol in the body at the forefront in order to make the demand. So the officer makes the demand. If the person says, no, I'm not going to comply, that's pretty much the end of it. You're guaranteeing yourself a 90-day driving prohibition just by the word no uttering from your mouth. There is no obligation on the police to tell you what the consequences of non-compliance are. This sort of mens rea, as we think about it, for refusing to provide a sample is that you're aware that a demand has been made. That's all. So you have to know that a demand has been made, and if you know that a demand has been made, then that's it. You are guilty of refusal. But in the circumstances where people blow, then that's where there's sort of divergent paths that can occur. In situations where somebody blows and they provide a sample that registers either a warn or a fail, that's going to trigger a right to a second test. So what happens after you blow a warn or a fail on the breathalyzer is that the officer will then offer you, or should, hopefully, if they're following the law, offer you a second test. The second test, by law, must be conducted on a different breathalyzer than the first one, and the lower of the two readings will prevail. This means if you blow a warn the first time and a fail the second time, nothing's going to get worse for you because you exercised your right to a second test. Similarly, if you blow a fail the first time and you blow a warn the second time, you're going to get a lesser prohibition. Or you pass the test the second time, you're going to get a lesser prohibition. The officer cannot offer you a second test or conduct a second test if you pass the test the first time. So if you do not blow a warn or a fail, there is no right to a second test, and the officer can't try and get a reading because, again, in any event, the lower of the two results would prevail and the lower is the pass. But also there's just no right to do that. So if you've passed the test, the officer says, oh yeah, you're under the legal limit, you're free to go. subject to any other reason that you've been detained. But there's no immediate roadside prohibition that goes for that circumstance. So you always are incentivized to blow. You're incentivized to blow because if you refuse, you're gonna get the consequence no matter what. Whereas if you blow, maybe you'll blow a lower reading than you think. Maybe you're not over the limit and you pass the test. Maybe you'll have a problem with the breathalyzer that you can use to challenge it. Now, assuming you blow a warn at some point in the investigation, what you're going to get is a 3-day immediate roadside prohibition. This means your license is suspended for 3 days. The vehicle can be impounded for 3 days, but it's a discretionary impoundment. And in circumstances of the 3-day prohibitions, there's also a fine. But if you've blown a warn before, then the officer can issue you a 7-day prohibition. And if it's your 3rd time blowing a warn in your life, then the officer can issue you a 30-day prohibition. So the more you get, the more prohibition time you're going to serve. The impound is still discretionary for the 7-day prohibition, but it is not discretionary for the 30-day prohibition. If you blow the fail and you don't get a lower test result at any point, either you refuse the second test or you take a second test and it's the same reading, then you're going to receive the 90-day immediate roadside prohibition. And the 90-day immediate roadside prohibition comes along with a mandatory 30-day impound, a $500 fine, and all of these other associated consequences in addition to it. So there's a big incentive as well to people to risk it by taking a second test. I am generally of the opinion that taking a second test could be detrimental to your case. And this is because if you are challenging the prohibition, you have very limited grounds of review. Your grounds of review are as follows. Number 1, that you did not drive or have care and control of a motor vehicle at a relevant time. So, you weren't driving, you were in an accident, the driver ran away, and you're left there, with the keys going, what the heck, buddy, why'd you leave me, right? You didn't drive. Or, in some circumstances, people who are not in care and control of the vehicle, like sleeping in the driver's seat. A risky thing we will discuss in an upcoming video, but something that is possible to argue defeats your care and control of the vehicle. The second ground of review is that the results of the test are not reliable. And this relates to things that could have falsely elevated the test results. Something like burping, belching, regurgitation within 15 minutes of the test that brings up undigested alcohol from your stomach into your mouth, resulting in a falsely high reading, or circumstances of a person who's recently consumed alcohol in the last 15 minutes and has residual mouth alcohol contamination, or contamination from things like vapes or candies, or elevated mouth temperature due to having a fever. Anything that could affect the reliability of the result is a defense. And this is where the second test problem comes in, because in the circumstance where somebody takes a second test, not only do you have to show that the first test was falsely elevated by one of these sources, but you also have to show that the second test was as well, because your right to a second test doesn't mean a right to a reliable second test. It just means a second opportunity to challenge the result. And so you have to make sure that both tests are unreliable for some reason in order to have the prohibition revoked on that ground. Now, the third ground of review that applies in these cases is a situation where a person was not over 80 despite the fail readings. And this is what we colloquially refer to in the industry as evidence to the contrary. It is the 2-beer defense. You lay out what you had to drink, when you drank it. You use a calculation called the Widmark formula, and this determines what your blood alcohol level would have been, factoring in both absorption and elimination. Again, why I don't recommend a second test, because if you did only have 2 beers, you don't think that you were over the limit, and you want to challenge the prohibition, 2 tests that are not affected by any other reason on properly calibrated devices, those are going to be tests that are given a lot of weight by the adjudicator.